Hello, my name is Harmanpreet Kaur. My student ID is 201733811. A contract can be defined as an agreement that is legally binding between two parties. There are various legal elements that have to be present for a contract to exist, which includes consideration, agreement, intention, offer, capacity, legality, and genuine concern. In Australia, the common law is administered by the judge-made law or the common law. This session considers some of the cases contract law while giving reference to previously administered cases. Here I am going to describe the current West David case. The case of Davy West Current is one where the judges should consider the aspect of rebutable presumption against contract formation. This is where the court makes the assumption that a contract involving family members does not exist unless there is evidence to show that it was legally binding. The law states that there is a rebutable presumption that a legally binding agreement does not exist between people with social relationships or family members. Curran therefore has to show evidence of the existence of a contract since it involves siblings. Similar case, the case of Curran v. Davy is similar to that of Waking v. Replay 51 SR 183, where a wealthy widower requested the Wakelings to relocate to Australia from England to take care of him. The Wakelings had to make great sacrifices as the husband had to resign hence forgo his pension and salary. Ripley offers to give some house content and bulk estate in return. The Wakeling agreed and sold their property in England, and Mr. Waking also resigned. However, as they were living together, they fell apart where Ripley altered the will and sold the house. The Wakeling sued Ripley for damages and breach of contract. In the ruling, the court sought evidence as to whether the contract was legally binding or just a mere agreement. The Supreme Court ruled out the sufficient evidence proof that the parties had a contract. The court made a ruling that the arrangement, communication of two parties, and the seriousness of the relocation of the Wakelings shows the intention to have a legally binding agreement. The plaintiff therefore won the case. In the case of Davy v. Curran should provide sufficient evidence that would make the court to rebut the perception that family members' agreement have no intention to create legal binding agreement. Curran should also prove that there was intention to enter into a legal binding agreement. Curran should also show the consequences she suffered as she had to relocate, resign, and sell her house as a result of accepting the offer to inherit their property. The legal issue in this case is whether there was intention to enter into legal relations. With all the proof of all the existence of a contract, the plaintiff will win the case.
Hi, my name is Narinder Kaur. My student ID 201735777. Explanation. The legal issue under concern in this case is unconscionable transactions that involve weaker and dominant parties. The pair should focus on preventing unconscionable behavior under equity where the party take advantage of special disability on other party to the contract. Disability include age, lack of education, illiteracy, even the combination of various factors that 11th part should provoke that they were the weaker party has specially disability than and the contract lack equity and that why they are breached the contract. The absent parents should provoke various factors so that the case can be ruled unconscious conduct. The parents should provoke that they have a little understanding of English or formal education in relation to mortgage and or also age. The parents should provoke that the bank took unfair advantage of their bargaining position for commercial gains. Explanation. The subject matter of the cases of Brent and Jane Ng will revolve around the concept of forcibility and the remoteness of the damage. Remoteness refers to testing and coercion legally and is useful in the determination of the categories of lose the result from the contract breach and
Hi, my name is Manpreet Kaur and my student ID is 201737111. Here I am going to explain the question number 3. Jenny and Treat can sue Aggie and can demand for the amount of damages. Brad and Jenny can only receive the damages and sue Aggie successful if they had made it clear to her that business cannot operate without having the wood fire oven. The two also to prove to the court that Aggie was aware of the damages that delay could cause. The plaintiff should be aware that a non-breaching party is only entitled to those damages that arise naturally from the breach, and also those have a reasonable contemplation while entering into the contract. The plaintiffs must also prove that they communicated with the defendant the special circumstances and the defendant understood them. The next question is question 4, which is related to the Mrs. Tillo who lost her belongings and luggage and also get injured. Gallagher with the bus tour company. The relevant case, like the one of the Gallagher, is that a Baltic shipping company with Tillo in 1993, 176 CLR 344. In this case, Mrs. Tillo was a passenger in a ship that was owned and operated by Baltic Shipping. The ship sank on the 9th day out of the 14 days period journey, which is paid. Mrs. Chillo suffered injuries and also lost her belongings. Mrs. Chillo sued Baltic Shipping for damages and cost of the cruise. It was ruled that Mrs. Chillo could only get part but not full compensation, as she had already enjoyed 9 days out of the 14. The compensation was founded on the implied or express term of the enjoyment derived from the holidays. Similarly, Gallagher should not sue for the total compensation since he had already enjoyed 12 days. The loss of the property cannot be compensated, as in such situation, physical loss damages are not compensated. Gallagher should also know that damages cannot be compensated in cases where the loss undermines the contract point. In next, I'm going to talk about the existence of the contract and relevant case. In the existence of the contract, Zilla do not have the contractual obligation to sell the television to Tom at the rate of $200, as there exists no contract between the two. This is because the advertisement of the sales related to the consumers, like the plasma television, is not considered as a contract or an offer to initiate a contract. Brochures, announcements, or catalogs are not considered as offers. An advertisement is therefore not a legally binding agreement with the customers. This means that Tom cannot sue Rosella in a civil court. The advertisement was also not misleading because of the great differences with the actual prices. Advertisements are deemed as innovation for doing businesses where the customers make the offers to purchase and the sellers can either accept or reject it. In the relevant case, the case Taylor and Johnson 1983 SCA 5 is relevant to this case study where the seller advertisement the price sale of 10 acre as a rate of $15,000 under the mistake that the price was $50,000 per acre. The purchasers was aware of the vendor's mistake but did not question. During purchasing, the vendor refused to sell the land at the rate of $15,000, claimed that it was for an acre, not the whole land. It was ruled out that advertisement was not legally binding, hence the vendor should not pay for the damages. Hence.
Hello, my name is Harmanjot Singh and my student ID is 20173512. Today my topic is Australian consumer law. Australia consumer law prohibits businesses from making misleading or false representation relating to the value, quality or the rank of good, accessories, benefits, uses, origins, or even the characteristics of a given good. The provision states that businesses should display accurate and clear prices and should not mislead the consumers about the prices. In this case, might Rosella breach this provision by providing lower prices? ACL also has a provision that claims in the businesses should be accurate, true and based on reasonable grounds. The provision on the Australian Consumer Law S29 provides that misleading or false representation relating to the price of goods and services. Further, a business is expected to display the total price that is inclusive of all duties, taxes, and any other pre-selected or unavoidable extra fee. The business should never mislead the consumers about saving on a given product or a service. Part 2, that is tort law case studies. Introduction to the tort law case studies. A tort can be defined as a legal wrong that is committed by an entity or a person against another entity or a person and attracts that usual remedy of damages award. A law tort protects the fundamental liabilities like fundamental rights and personal liberty inclusive of property right and provision of protection from intrusions by other entities or people. Torts therefore protect people from wrongful conduct of others and provides the claimant the right to sue for an injunction so as to contain the conduct or compensation. This part analyzes various tort cases and provides advices to the claimants. Jean versus East End Four Corners Supermarket. In this case, there was a high probability that the risk would occur if not taken care of, and the result was a broken ankle. In this case, it is also evident that plaintiff would not have broken the ankle if the defendant had adhered to their duty of care and checked the floor after every 15 minutes as required. If Jean becomes successful in proving that there were an act of negligence from the supermarket, the remedies for the harm caused will be damages. Damages refer to compensation terms which may include emotional distress, lost wages, suffering, or medical bills. The defendant also have possible defenses. This includes claims of carelessness, comparative negligence, or even clumsiness can form part of the store's possible defenses. The fact that a customer slipped and fell doesn't necessarily mean that the store owner acted in negligence because every person owes themselves a duty of care when passed through certain places. The property owners are therefore not liable for any damages caused by an act that could be avoided by a reasonable person. Applying the concept of comparative negligence, if the accident occurred because Jean acted negligently, the store has room to mitigate the damages so that it can be avoided. This is only possible if the defendant proves that complainant engaged in activities that contributed to slipping and falling. Thank you.
Myself Mohammad Sami and my student ID is 20173794. So now I am going to discuss Len versus Johnny case. Len must prove that there was breach of care from Johnny that resulted to the damages. He has to show evidences that Johnny failed to exercise the reasonable care. For Len to successfully sue Johnny, there has to be proof Johnny O. The duty of care. The duty of care requires a property owned to ensure that their property are reasonable, safe for Johnny anyone who gets into the property. The owners of the property also have a reasonable duty to ensure that common areas such as stairwells and parking lots are safe. Putting this aspect into consideration, Johnny owes a duty of care to Len. This is a duty of care that exists between an employer and the employee. One of the questions that is important in determining if there was a breach of duty of care is if the defendant could predict the risk that caused the damage. The hailstorm was not predictable and the risk could not be prevented. The second aspect to consider whether there was a breach is the aspect of negligence. Negligence is a careless conduct of an individual that result to harm on an individual. Negligence is also evidence when an individual failed to do something. In this case, Len would claim that Johnny's failure to open the garage that result to Len parking the vehicle elsewhere. In this case, Johnny failure to open the garage was not the case of the damage. In this case, there is no breach of duty and Johnny is not liable for the damage. In the case of Sam versus Polly, Polly knew that Sam was inexperienced but accepted the lift through implies word. Secondly, saw it was raining heavily and Sam had trouble in keeping the vehicle on the road, hence chances of an accident, but still continued to stay in the vehicle. The third proof that shows that Polly voluntarily assumed the risk is the fact that Polly saw Sam overspeeding, and even though she warned him and did not slow down, she still remained in the vehicle. The fact that Polly assumed the risk means that the defendant does not owe Polly any legal duty. The element of duty at the negligence claim would thus not be fulfilled, and the plaintiff cannot be compensated for any risk resulting from the defendant's negligence. Another defense which the defendant could use is that of contributory negligence. Contributory negligence is the failure of an individual to take reasonable care regarding their safety, which result to injuries. The principle that guides the contributory negligence defense is that every person should take reasonable care of themselves and safety. In this case, Polly could have prevented herself from being injured by either not boarding the vehicle or alighting when she found out that Sam was overspeeding. The risk was foreseen there, and the plaintiff can the ability to avoid. Proving such will result to reduce damage. A contract is an agreement that is legally binding. A contract that is legally binding must have the agreement, intention, consideration, offer and acceptance. Contract between family members must prove the intentions to enter into the legal agreement. Failure to fulfill the promise in the contract result to breach that is compensated as damage. A tort, on the other hand, refers to an omission or an act that results to a harm or an injury. The elements in tort include causation, duty of care, breach, damage, and duty. For an individual to successfully sue for damages in tort and contract, they have to prove that the elements in each existed.